Welcome, everyone. Thank you for braving the weather to come out. I think tonight we're going to have in fact, I know we're going to have a very stimulating, informative, and proactive program. As Barry said, it's co-sponsored by NYCLA's Ethics Committee and Cyber Law Committee. We have a group of expert speakers to discuss what is going on in the online world, what the risks and benefits are for lawyers, and to present these questions, I think, from many different perspectives, many different aspects of them: ethics in the narrow sense of lawyers' duties, the broader sense of privacy and other societal interests. We'll look at technological developments and practical insights. We'll go to our next speaker, Jonathan Stribling, who's on my far right. And Jonathan will take a deeper dive into some of the emerging legal and ethics issues. Jonathan is the Director of Constitutional Communications. He has led many trainings or CLEs for attorneys on cybersecurity, encryption, privacy rights, and attorney-client privilege communications. He has also done security audits or training for journalists, grantors, human rights workers, and technologists at the Center of Constitutional Rights, the Legal Clinic of CUNY School of Law, and the Continuing Legal Resources Network at CUNY, among many others. And again, there's more about Jonathan in your materials.
Jonathan, basically, I have the unenviable job of talking about mass surveillance and kind of the larger perspective, as well as the technology that we mentioned a little bit, but also that's enabling kind of some of this stuff. So when I say mass surveillance, what am I talking about? It's a very specific definition that I'm using from the UN, actually. And they define mass surveillance as a situation in which states with high levels of internet penetration can gain access to telephone and email content of an effectively unlimited amount of users and maintain an overview of internet activity associated with particular websites. The UN report summarizes that to say that all of this is possible without any prior suspicion related to specific individuals or organizations. So this is what we've seen created by a number of different governments at this point, and this affects attorneys here in the US. We've seen large law firms like Mayer Brown in Chicago, which is a global firm, have their information taken during negotiations that they were in with representing the Indonesian government against the US government in trade negotiations, and their internal attorney-client privilege information was taken by the NSA as part of the NSA's mass surveillance and used against them in litigation. We have US-based attorneys generally, and then we also have some of the encryption tools that attorneys have relied on in the past that have also been undermined. So in terms of the big perspective, what does the US, the UK, Canada, New Zealand, and Australia have in common? Well, they're all part of the Five Eyes, which is their internal name for surveillance kind of sharing agreement that they have. So they're also all former British colonies, or Britain itself. They all have white English-speaking majorities and power structures. Their intelligence agencies were in tight coordination in World War II, and they've maintained that coordination. So that's kind of where this all comes from. It's a geopolitical question. And this is an example of what that looks like. So the second parties in this slide, the US would be the primary party, and then the second parties are Australia, Canada, New Zealand, and the United Kingdom. And the third parties are countries that they share intelligence with on a massive scale at specific times. So they'll have memorandums of understanding where they will grant intelligence sharing with, we've seen memorandums with Israel and with Saudi Arabia. So this is, for years at a time, they are allowed to search through the NSA databases that are shared with the four other countries there. So this gives you both a little picture into global politics, as well as kind of makes it clear that this is kind of a large-scale problem that also affects clients that may be from other countries as well. If you're representing a company or an individual in another country, their government could be getting information that would be taken from the US monitoring, depending on their relationship with the US government at a given time. So this is part of an overall strategy on the part of these five agencies, as well as we've seen other governments as well. So France recently has come out, since 2008, they've been doing similar things. And it looks Russia and China are pretty similar in their posture on this, but this is from a Five Eyes conference. They have yearly conferences, and this is from the 2011 conference, that their collection posture is collect it all. So collect all data all of the time in order to be able to use that in the future at some point. So when we say collect it all, that's kind of a big statement. What would that kind of mean? How would they technically be able to do that? Well, they kind of thought about this one a lot. So this is a facility that opened in 2013. It's in Bluffsdale, Utah. It's the Bluffsdale Data Center. It's designed to hold a yottabyte of data, as you were saying. These concepts are very large. Yottabyte is the biggest data metric that has ever been defined. It's 1,000 times more data than all of the internet will be at the end of this year. So take the whole internet, multiply it times 1,000. That's what a yottabyte is. It's actually named after Yoda, incidentally, from Star Wars, because math people are dorky. But that's, so they're thinking about this long term, and this is where they're getting this area to fill this data center, right? So they have two types of collection that they do in general. And as you can see from the slide, they Gmail, Facebook, Hotmail, Yahoo, Google, Apple, Skype, PalTalk, YouTube, AOL Mail. So that's the PRISM program. It's been reported and in a relatively big way. And then the upstream collection is actually tapping the fiber optic cables that are the backbone of the internet. So this is basically, the internet is a series of tubes underneath the ocean mostly, where all the servers are connected. If you look carefully at a map of the internet, this is such a map, you can see that about 99% of traffic passes through one of the Five Eyes, right? So you have the US and Canada, the UK, and then New Zealand and Australia. 1 point on almost all of the internet traffic is in those countries. So then they just tap the end of those points and are able, and then send that to the data centers, right? So this is a slide that those names are not geographic names; those are code names, but those are the access points within the U.S. area, or some of them, within one specific program. So that's how they're able to kind of do mass surveillance as a normal phenomenon within internet communication. And so it also is important to understand how the tech works in terms of email and stuff like this. If I'm standing here emailing you across the room, that email travels in the cheapest path, not the physically most direct path. It's based on the pricing of electricity at the moment that I send the email. It could go to the UK and come back. It moves at the speed of light in the time that it takes for me to send an email to you standing over there. That means that they're able to tap that with different legal authorities as it exits this country and goes to other countries, right? So as governments make agreements about information sharing, it means that individual national governments have a hard time regulating or coming up with any type of way to challenge this type of collection, right? Because it is an international phenomenon. So this slide also shows the way in which the amount of data collected. This is flows of data between Europe, Africa, the US, Asia. And so you can see that the amount of data that's being collected and the way in which the Five Eyes allows that to function. So a little bit about the background on the technology. First, the what of communications is written emails, posts, and text. That's what you normally would type into your computer. That's content, right? So then there's metadata, which is data about data. That allows it's like a fingerprint of the interaction that allows for an easy networking and social network to emerge from the patterns of communication. And then there's geolocation data, which is like your phone is constantly communicating its physical location to the network in order to get a signal, right? So if someone is able to control the network, they see where you are. So phones are tracking devices. Computers' IP addresses give a general location. Unless you're masking the IP in some sort of a way, you generally give the individual machine and the network that you're using it on, which also has a geolocation component to it. But those are three things that it's important to keep into account, and there's different ways that databases are built around those things. But this is probably the most kind of broad-ranging tool that the NSA and associated organizations use, which is X-keyscore, so they can do content-based queries on all email. And basically they just do search with search terms for those emails. As you would search Google, they can search email. And then they do that through strategic partnerships. So they have partnerships with, this is their slide also, with 80 major global corporations. So that's Microsoft, AT&T. We're going to see more about how that affects the structure of this and how that affects some solutions that attorneys that aren't those corporations need to think about if you would be representing that. So this is also the cell phone question around, they collect, in some countries, we're not sure about all of them, they just collect the whole cell phone network. So you're able to get all locations of cell phones over time, and then you can put that together to show relationships between people. So if someone had a meeting, their two phones were in the same place at the same time, and then you can prove that that happened. Or in this case, this is from the Washington Post. This is how they follow, or they know that someone is following an individual, because over time you go through different cell phone towers. And if you have the whole network, you're able to see how the phone moves through each of those towers. So even if you don't know the specific location, you know the general location of movement. And then you have kind of the most extreme example that we've seen, which is in the Bahamas, strangely. We'll explain why. But so this is called the Sommeljet program, and basically it's full forward, take metadata in real time in a buffer of full take audio for 30 days. So they take all of the phone calls from the Bahamas and store them for 30 days. Why the Bahamas? Probably because that's where most offshore banking is from the US. That's the operating assumption. So if you're representing a client in the Bahamas, it is important to encrypt your phone calls, which is not that hard to do, and we'll talk about that as well. But it's something where, at this point, that's the norm for that country, and we're seeing more and more collection happening like that, that are even on kind of a countrywide basis. So then how does the NSA use this information, or how does, in this case, this is the SOD, so this is the federal government under the DEA actually, and they're able to search for, as you would kind of search, they say Google-like search for pattern of life, target alerting, and results. Right, so, and this shows the information sharing regime, so between the NSA, the Five Eyes, and then federal government, CIA, FBI, DIA. So they have direct kind of information sharing, which can come up in, obviously, criminal matters. They also have, the New York Times reported that they installed 100,000 key logging malware programs on computers globally. I believe The Intercept reported 50,000. But basically, this is a map that gives some geographic ideals around that, which is, again, their map, which the red dots are the key logging malware. What key logging malware does is it actually gets each keystroke on a computer that's compromised by it, or each screenshot, conceivably. And so this is where we've seen, a lot of this is probably on government computers, but this is also something that attorneys need to take into consideration if your clients are being targeted by a government that may be of interest, or if you have a corporation that has information that they're trying to keep secure for IP reasons or for criminal or other matters. So in that regard, that whole partnership relationship, it makes it a little more difficult to build secure computing systems. So Microsoft shares its software bugs with the NSA before releasing them to the public or antivirus vendors. Right? So that means you can't build a secure Microsoft system if your adversary is the NSA, because they will get the bugs before you have an ability to fix them. So the way to avoid that is to use open source software, but we're going to get more into how that exactly works and why that's important. Also, the footnotes for all of this presentation, are in the material, so if you want to go look it up yourself. And then at some times we've seen this was a big thing. Cisco sent a letter to the Obama administration because this is the NSA breaking into a Cisco, it's called package interception, where they actually intercept the packages as they're being delivered to a vendor and put surveillance devices inside of them. So this causes a big bump in Cisco's share price, or a big loss in Cisco's share price. But this is something where another reason why encryption is so important, because even the vendors aren't always able to make sure that the information systems that they're providing have not been tampered with, even in transit, right? We assume this is mostly governments that are being targeted by this, but we don't know how much this is being used. So the Washington Post reviewed 22,000 finished surveillance reports, and they came up with a whole kind of view of where this information is coming from for an outgoing report. And the key thing kind of takeaway here is that only 11% of the reports have information that is coming from NSA targets. 89% is information that's coming from associated parties. So that can be an attorney, that can be a friend, that can be whatever. This is how mass surveillance works and why it's different than normal surveillance, is that it sucks up information from everyone surrounding a target. It also is the case that at this point there's about approximately 1.2 million people on some version of a terrorist list in the US at this point. So that means that approximately 80 million people are conceivable to end up on surveillance in the outcome of surveillance reports. It's also an issue of industrial and technological development. So this is where they monitor the development of technology itself in order to ensure, as they say, effective forecasting in geopolitical regions and targets. They ensure that they introduce vulnerabilities where they do not yet exist in ongoing communications technology. So this is why it's difficult to rely on large-scale vendors that have partnership relationships with the NSA or other national governments, because part of their role is to break those tools to make sure that they still have access to them. That's stated in their kind of reason for being, and also shows a difficulty with their overall strategy, which is that they both are supposed to secure systems as well as to break them to be able to exploit them for information. And so this is where, at this point, the NSA has a very short-sighted strategy of how this looks, because they've introduced vulnerabilities into a lot of the things that we rely on as professionals. This can go as far as kind of cyber stalking employees. This is the internal transcript from Gemalto, which is there's two manufacturers of SIM cards for phones. And the SIM card has an encrypted key on it in order to connect to the network. The NSA stole all of the keys for all of the Gemalto cell phone by cyber stalking their employees and taking them when they were first put on when they were being manufactured. And this is an internal transcript of that. But that's kind of gives you a sense of how big this question is and why it's so important that attorneys have your keys yourself. And we're going to talk more about what that looks like. And in terms of how the keys kind of work in the whole question around encryption, we've seen a number of different encryption manufacturers compromised by either their relationship to security agencies or by the technology itself. So the industry, the NSA basically paid off. This is a specific technology called dual ECDRBG. It's a type of proprietary encryption. And it basically, they put a backdoor in that encryption, meaning that the random number generator that was generating the key that's supposed to lock everything wasn't really random, so that they could guess what the number would be, and then it would undermine the system as a whole. And so this is where this type of encryption, they got RSA, which is a major manufacturer, to include it in its overall kind of packages by paying them $10 million. And then it was included in BlackBerry, Microsoft, CertCom, RSA, Juniper Networks, McAfee. There's a whole list there, Symantec. This is from their patent request. And then the NIST, the National Institutes of Science and Technology, removed that in 2014 after the Snowden revelations came out and showed that they had actually compromised that form of encryption. So this is why it's really important to use, also Skype did a similar thing where they said they were encrypting their phone calls. They actually had worked to undo that encryption as well. And Snapchat too, for all you Snapchat users out there. They weren't actually effectively encrypting their information, although they said they were, and hackers actually took a lot of the information from Snapchat. So I'm going to skip these. Well, actually, let's do this. So this is why we see this as not just an issue this is for technical competence, and it's also for the integrity of our profession, because it's clear that the NSA's interests are, and the government's interests are around control and not just security, right? And control of information and control of technology and long-term planning. So as they say, serving their customers, agricultural justice, treasury, and commerce are part of those. Those are all issues where an attorney would be intimately involved with these parties. And this is their own presentation about the fact that it's not so much about the threats that they're focused on, it's more about ensuring that they're able to gain more status and control for the US. So this is a presentation that they gave to NSA officers that says, oh yeah, put money, national interest, and ego together, and now you're talking about shaping the world writ large. What country doesn't want to make the world a better place for itself? So if your client happens to be someone who's not from the US or has an antagonistic relationship to the US, it's important to understand that this technology needs to be in your interest and not in their interest. And so this is where, in one of the more important documents I think that's been underlooked, that's come out, is the Quadrennial Intelligence Community Review, which is kind of a fun sci-fi document that came out about 6 months ago. That's the NSA planning from 2009 to 2020. It's 25-year plans. Every 3 years they do a 25-year plan. And so they have key strategic points, and one of those points is technology acquisition by all means. See, the idea is that with this kind of network access, they're able to control the development of information technology. So, and technology as a whole, because they specifically talk about the ability to take IP information from people in Russia or China and patent it in the US before they're able to patent it in other countries, and then effectively change the balance of power around technological development. So that's why this is a long-term plan. This is not a short-term thing, and it's not going to change with just a short-term strategy or short-term perspective for attorneys on this issue. It also does relate to defense, obviously, and war making. So the first cyber weapon ever released was released in 2011. It was called Studnik's worm, and it targeted industrial systems in the Iranian nuclear facility in Nanuts, which is a civilian nuclear facility that it caused their centrifuges to explode because it would spin them too fast. And so this is the first example that we've seen of this type of cyber weapon, and we're going to likely see more of this, but this is where we need to be thinking critically about how these things can be prevented from our technology in particular, and then in general we need to talk about how we need technology that's about security and securing our information and not about being able to utilize it for weapons programs and this sort of thing. So there is a legal framework for this. It's the, FISA, there's a Executive Order 12333, which was an executive order that Reagan passed in '82, and the Patriot Act as well. And so this is something where, at this point, the difficulty is a lot of the legality around it has been shrouded in a ton of secrecy. We don't get to see the actual reasons. The definitions in many of these things are dual definitions, so that they're one definition in the congressional record, and there's another definition that the NSA has for something like collecting. The NSA doesn't think if it's collecting something, it's not viewing it, so it doesn't think it's violating privacy rights around that. So to move to more kind of the more hopeful stuff that Pete's going to get more into, open source is one way to avoid some of the biggest problems with this kind of software development, where we see these systems that have been compromised. And I just want to clarify what that means. It means that engineers and users can see the codes, the source codes of the computers that are the software programs that are making the computers function, right? So if you can't see those, if they're held behind because of licensing or proprietary restrictions, you can't be sure that the computer is doing what you think it's doing. And so having it be open source allows you to actually see that. And this is actually a principle that's a scientific principle in cryptography and the science of making codes that's important to this background in encryption. It's called Kirchhoff's principle, and it's that the security of the system has to be based on the assumption that anyone attacking it would have full knowledge of it, except for the one random code, or the code that that you need to keep secure. Everything else should be open, because then you can be sure that no one has modified it against you, right? So this is the only missing information for an attacker is a short, easily exchangeable random number sequence, which is the secret key. So this is a baseline in how encryption should function, and this is why open source is very important for effective encryption. Also, thankfully, because of the way computing works, open source generally means free. So that makes it easy for attorneys that don't have a lot of money or small firms to actually create high levels of security without a ton of money. So this is important to be thinking about. And we're going to go in more into that. Another thing is that end-to-end encryption means the person, the user, actually holds the key, right? So if there's a lot of systems where a third party, the vendor, will encrypt the information and then will hold the keys and open it up for you when you put in your password, but you're not actually holding the key. So the issue there is that if the vendor is compromised or if their systems aren't something you can see, then you're not able to actually be sure that that information is secured. So this is where we're going to talk more about this and kind of have some back and forth on it, but that's the basic idea. At the moment, lawyers play a really crucial role around securing information of clients and society in general and having a conversation about privacy and our need for that as a profession, as well as individuals. Unfortunately, at this point, most attorneys, if you're hacked, there's no reason to publicize that. So this is happening very often. I've given trainings where the organization I was giving the training for came up to me in the middle of the training and told me they were getting hacked at that time, that their information had just been compromised, which was really weird. But this is something that is happening often, but there's no reason, they never publicized that. Right? They came up to me and told me in confidence, and I'm telling it to you in semi-confidence, but they did not go public with that, right? And you wouldn't, because why would anyone go public with a hack unless they were forced to? Because it just makes you look incompetent. And so you don't want to tell anyone. As an ED, as an organizational director, if a staff member comes to you and says you think your information has been compromised, you probably are not going to say, let's go to the media with this. And if you're a nonprofit, you certainly are not going to say, let's go to the media with this, because you don't have anyone to go, you very rarely have information technology staff that's very competent or that is full-time. And then, Access is probably the one difference in that he'll talk about that, but in general, you have a very hard time as nonprofits or as civil society organizations, foundations. You don't have staff on hand to help you with information technology compromises. And this is threatening the profession as a whole, because as clients realize that their information is not as confidential as they were hoping it was going to be or has more risks to it, they're less willing to divulge things and less willing to come to attorneys. So we need to take this very seriously as a profession. Massachusetts probably has the best clear guidelines on this, which is actually for all private businesses, but also applies to attorneys, which requires encryption for personal data held by private companies, including out-of-state entities that deal with Massachusetts residents and the data of Massachusetts residents. So this is, Nevada also has a not too dissimilar standard, but, and they've been more aggressive about it. They've gone out of state. Massachusetts has, the Attorney General had a settlement last year of $150,000 with a Rhode Island business that lost the data of Massachusetts residents. So this is something where if your data is compromised, there should be a way to actually ensure that it was encrypted, and if it wasn't, that should be something that you can be penalized for. We're going to talk more about security audits and that kind of thing. But then, so this is the specifics of the law, which just what kind of information are we talking about, and it applies to persons who own, license, store, or maintain personal information about a resident in the Commonwealth of Massachusetts, and it applies to to the extent technically feasible, encryption of all transmitted records and files containing personal information that will travel across public networks. So that's both at rest and in transit, which are two separate things with encryption. We already went over the model rules. And so at this point, the ABA has upped some of the rules around client confidentiality and attorney-client privilege information, but we have not seen them take a more proactive stance. But as New York, we can do that in terms of making sure that we're securing information of our clients and increasing the definition of reasonable effort to ensure that that information is kept secure through changing the definition of reasonable effort to require the provision of end-to-end open source encryption for private information at client request. Right? So every attorney should be, as an ethical responsibility, should require that their information be encrypted at rest and in transit with a key that they hold. And that way, you have an information system that then will be secure both from government as well as from any hackers or attackers that are coming at the network as a whole. And this is, we'll be talking more about this, but it was just to put out there, this is kind of a way to change the specter of mass surveillance and ensure that attorneys will be secured with private information, even if this kind of surveillance maintains itself over a long period of time. Thank you.